the Sunshine State. This is Tampa Bay's Tan Talk.
It's time for FLA Law, brought to you by personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday evening, and my name is Matthew Noyes. I am one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, and we proudly sponsor and host FLA Law on the radio every Tuesday from 5 until 6. This is a live call-in legal talk show, so if you have any questions regarding the law, give me a call at 727-441-3000 between 5 and 6 o'clock tonight. My guest was unable to show today, and so you have me for the full hour. And so I am here to answer any questions that you have, and also to provide some insight about the law. Our firm does personal injury law, which is car accidents, slip and falls, trip and falls, any types of negligence that may occur. We also do work injuries, workers' compensation, and we also do Social Security disability claims. And so I'm here to answer those questions. And, later on in the show, I'm going to have a few what I call hey Matts. And really what those are people stop me and say, hey, Matt, what about this? Hey, Matt, what about that? And so I'll be able to answer some of the questions that most people think about before without having an attorney available. But I'm here to answer those questions and answer any other questions that you may have. But as I said, our show, FLA Law on the Radio, is hosted by the personal injury law firm of Perenich, Caulfield, Avril, and Noyes. We are the oldest personal injury law firm in Tampa Bay. This year, we're celebrating 70 years of helping people. And so for just a few minutes, I always, during this show, I always want to talk just a little bit about memories of Perenich, Caulfield, Avril, and Noyes, and FLA Law, to show how important it is to be part of the community. So before we get started talking about our 70th, I do want to steer you towards our Facebook page too. We do have a live Facebook page. I just turned it on. I forgot to turn it on, so that's why I was stuttering a little bit there. But we are now live on the Facebook feed. The firm's page is Perenich, Caulfield, Avril, and Noyes Injury Lawyers, and so you can watch right on into our studio and ask me questions on Facebook if you'd rather not call in with any questions that you have. So again, it's Perenich, Caulfield, Avril, and Noyes Injury Lawyers live on Facebook. And so let's go back to our 70th birthday. I have been with the firm, now for 35 years. So about half of the time that the firm's been around in Clearwater. Our main office is in Clearwater, but we do have offices throughout Tampa Bay. Guy Perenich started the firm with Frank Muscarella, whose daughter is a local judge here. But Frank and Guy started the firm in downtown Clearwater, and Bob Carroll got joined soon, and it soon became Perenich and Carroll. And as partners came on, the name changed, but the dedication never did. And we have always been proud to fight hard for people that get injured because of the fault of somebody else. The firm now is Perenich, Caulfield, Avril, and Noyes. And we're right on Sunset Point, and Belcher is our main office. And so we're always happy to have you stop in and say hello. Some of my best memories about the firm was we did have an FLA Law TV show. Those who've been in the area for a while may have known that. It was a live call-in talk show as well, but it was on TV. It was before Bay News 9 was even around, because we were on Channel 9. We did 2 shows in Pinellas County and 2 shows in Pasco County with similar format. We would be available to answer questions that our viewers had. And we did that, for a long time. It was fun to host that show. and also to be a guest on the show. I met a lot of nice attorneys and not a lot of nice people from doing that show. But another memory I have about our 70 years in Tampa Bay was we used to have what's called Client Fun Fest. We have a baseball game, but we used to have a fun fest, and we would rent out Coachman Park, and we would have hundreds of our clients and their families come and just enjoy the day, take a break from all the stresses and everything, and just enjoy the day with us. We had a petting zoo there. We had games that they could play. We had a band there. It was so much fun. And that was before Coachman Park was renovated now into the Sound and such. It's still beautiful over there now. But we had some great memories over on our fun fest days with our clients. And I think that really kind of tells us why the firm has been together for 70 years. Is because we always do put clients first. We meet a lot of great people, unfortunately, after bad things happen to them. And so we want them to know that we don't see them as a file. We see them as a person whose life has been thrown into a tailspin sometimes because of a car accident or because of a work injury or just because of a trip and fall. And so it's our job, it's our dedication to, guide them through the legal process, to help them as best as we can. Guy Perenich started that philosophy 70 years ago, and all the attorneys have continued to carry on that same philosophy of putting clients first. And so we are proud to be able to serve Tampa Bay for 70 years. So again, that was my little 2 minutes worth of the firm and our 70th year anniversary. But what I did also want to talk about is it is spring training time. That means baseball, and I love baseball. Anybody who's listened to me has probably heard me talk about baseball all the time. And I just don't do it on the radio. I always have analogies that have some kind of baseball analogy when I talk about my cases as well. Well, and my son is 19 years old, and he just got offered to play baseball for a junior college in Georgia. And so we talk about baseball all the time. I coached the Little League for, many years, and he's played baseball all his life. And so baseball is a big part of me, but it's also lawyering is a big part of me. And so I, over the 35 years of being in the legal practice and the decades of being involved in baseball, have learned that being a baseball player and being an attorney have very many similarities. My son would disagree with me in that till I'm able to point out several things that both the baseball player and an attorney has to deal with when they're doing their profession. So I listed out 12 ways that a baseball player and an attorney are similar. And the first one is that both have to master the rules. Baseball players have to master the rules of how to play the game, and lawyers have to know what the rules of civil procedure are, or criminal procedure if you're a criminal defense attorney. If you do not know the rules, you cannot win the game. You will make mistakes. You will forget to do things. And so just like the baseball player has to know when they can steal, when they can run, a lawyer has to know the rules. And the rules are forever changing in law. In fact, we have some brand new rules for civil procedure that came into effect recently. And if you're not up on the rules, your clients are going to suffer. And so it's very important that lawyers master the rules just like baseball players have to master the rules. The second way baseball players and attorneys are similar is that strategy is the key in both baseball and in practicing law. Baseball players have to strategically plan how to outplay their opponent, and attorneys have to do the same exact thing. There's always strategies when we're developing legal strategies and trying to build strong cases and building the argument. You just have to know. It's like playing chess, but it's also like playing baseball. You have to know what your next step is going to be, and be able to pounce when your opponent takes their steps. And that's very similar to baseball as well. So baseball and lawyers both have strategy as a key to success in their professions. Also, evidence is very important. You say evidence is in law. Yes, that makes sense. But in baseball, umpires make calls based on what they see. That's the evidence that they have. When you have a claim against the insurance company, the adjusters are doing the same thing. They are making calls based on what they see, on photographs, on estimates, on medical records, on all types of reports that come into play. So evidence plays a crucial role in both baseball and in being a lawyer. One thing that I really strongly believe is being a lawyer, you have to be quick thinking under pressure. And a baseball player has to do that as well. A batter has to react to a fastball pitch in a split second. But an attorney also has to be able to think on his feet or her feet and to respond to an opposing attorney's argument or an unexpected development in the case. We had a mediation this afternoon in a workers' compensation case where something unexpected came up, where the defense attorney raised something that if we weren't ready to pounce on that, we may have believed what he was saying. But with our quick thinking, we could establish that the position that they were taking was totally false, a position that we never thought that he would be taking. But with quick thinking, then we were able to at least counter the argument that they had. The fifth way that baseball players and lawyers are common is practice and preparation. I tell my son this all the time, that you got to practice, and the kids that we used to coach all the time, you got to practice, you got to practice, you got to practice, you got to prepare, you got to prepare, you got to prepare. That's the same thing as being a lawyer. Lawyers have to spend hours preparing their cases, researching the laws, practicing their arguments before presenting it to a jury or to a mediator. It's so important that you are training endlessly before stepping onto the field, on the baseball arena, or into the courtroom if you're a lawyer. Anyone who does not prepare for a deposition, for a hearing, for a trial, is bound for failure. So it is so important for all lawyers to prepare. We spend most times actually preparing than we do actually going in front of the court and doing hearings and such. For a 1 week trial that we may have in an auto accident case, we probably spent about 4 weeks before that trial getting ready and preparing for everything that goes into that case. So preparation is so important. Why? Because of the sixth thing that baseball players and lawyers have in common. Errors can be costly. A mistake in baseball, such as a fielding error, can really change the whole outcome of the game. Same thing as a lawyer. If you commit error in the case, whether it's missing deadlines or providing incorrect information or not documenting damages that should be documented, those are errors that can be very costly to your case. So it's so important that we do our best to commit no errors, whether it's on the baseball field or whether it's in the courtroom. Errors can be costly. But yes, there may be some errors that occur in baseball, but that's where number 7 comes into play, and that's teamwork. Teamwork really matters, whether it's on the baseball field or whether it's in the courtroom. I see all the younger players on the spring training games trying to make the team, trying to show that they're a good team player. And that's similar to the courtroom. We have a team as well in our office. We have a team of lawyers. We have a team of paralegals. We have a team of experts. We have a team of our accounting department, our receptionists, our intake department, all as a team. And if we're not working together, we're not serving our clients the best that we can. So we know that teamwork matters both on the baseball field and in the courtroom and in the law office. But ultimately, winning or losing comes down to performance. A baseball player's success is determined how well he can execute on game day. A lawyer's success depends on how effectively they can present their case at mediation, to the insurance company, or even to a jury. So it does come down to performance. So important. And that's where we come into the practice and preparation. So you have to be able to perform. You have to be able to show the other side the strengths of your case. And that's where number 9 comes into play, and that's reputation and track record. A baseball player is judged by their stats and career performances, just like an attorney is evaluated by their case history and their success rate. And so that's 9 reasons. So I almost convinced my son that, okay, you wanted to play baseball, so now it's the same thing. Why don't you be a lawyer as well? He's not there just yet, but I'm still working on it. And that's what number 10 is. Sometimes it's about persuasion. Baseball players try to convince the umpire that a borderline pitch was a strike, or that the fielder tagged out the runner. And it's persuasion. They have to persuade when it's a close play. Attorneys have to do the same thing. Attorneys persuade judges, juries, insurance adjusters, clients, everybody, to persuade them to see the way the client's life has changed after an accident. So persuasion is so important in both baseball and in the courtroom. And the last 2 is kind of why people don't like baseball, I think, which I think is a mistake. But baseball can go into extra innings. It can be seem like it's dragging on, and that neither team is really going to finish this game anytime soon. And that's kind of like a court case. Legal cases, too, can drag on. They can go through negotiations. They can go to appeal. They can go into litigation. People get frustrated with the extra innings of a court case as well. But ultimately, it takes patience. And that's the 12th way that baseball and lawyering are very similar. Baseball games can be long. They require endurance, and they require focus. That's as the player, not just the person watching. But just like baseball games can be long and require endurance and focus, a case is the same way. You can't properly prepare a case where somebody is injured in a car accident in a month, in 2 months. The effects that a car accident have on a person's life can manifest themselves in 6 months, 8 months, a year, even 2 years later. So you need to be patient. You need to understand that your case may go into extra innings, but that's because your lawyer is willing to go those extra innings for you through their preparation and through their dedication to succeed. Patience is so important, and it's something that, I must admit, sometimes I lack patience in my court cases. I want the insurance adjuster to see it my way right away. I think there's a lot of times that there are what I call no-brainers, and that certainly they could see that we are correct in our assessment of the case, and they should tender the money that properly compensates our client. But they don't. And so we need to show them that we're willing to go to bat, and we're willing to battle for our clients all the way, even if it takes extra innings. So yes, I don't think that will still convince my son to be a lawyer. I don't think he likes it that dad takes home work every night and does birthday cards on the weekends and other stuff on the weekends. But I truly love being a lawyer. I've been doing it now for 30 years. And I can see how baseball players loved what they do. And I can also see a little bit of lawyering in the baseball arena. So I encourage everybody here in Tampa Bay to enjoy spring training game. It's beautiful. It was beautiful today. But while you're enjoying the spring training game or watching the Rays play, think about how is that job, because it is a job, it is a career, how is that job similar to being a lawyer? Was Matt right? Is a baseball player really like a lawyer? Or is a lawyer really like a baseball player? And look at it, and then look at your job and see how aspects of your job may play into baseball or basketball, whatever your sport is. You'll see that although different, just like in life, although different, there's very much similarities if we just look for them. So that is my little rant about baseball and being a lawyer. And I always encourage kids to get out there and really learn to play on a team of any sport, because once you get into the office or the courtroom or any place else you may go as a career, it's so important that you learn the fundamentals of being on a team, and so you can carry those with you to be a success in whatever profession yet you take. So we are still here, and we're able to take questions. That if you have questions, the number is 727-441-3000, or on Facebook, you can go to our live feed at Perenich, Caulfield, Avril Noyes, Injury Lawyers. I am Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, who proudly hosts this show every Tuesday from 5 until 6. We're going to take a short break right now, and then when we come back, though, we'll come back to answering some questions having to do with auto accidents. So we'll be right back.
This is the Tan Talk Radio Network.
After a car accident, there are many questions that you need answers to. Who pays for my car repairs? Who pays for the medical bills? What about my lost wages? And more. The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
Welcome back. This is Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, and you are listening to FLA Law on the radio. We proudly host this show every Tuesday. We're here to answer legal questions that you have regarding any areas of law that you have. We do specialize in personal injury, meaning we do handle car accidents, slip and falls, trip and falls, work injuries, workers' compensation claims, and Social Security disability claims. So if you have questions regarding those areas, give me a call, 727-441-3000. I am here live until 6 o'clock, and so I'm happy to answer any questions that you have. Before the break, I was talking about how baseball and lawyering are similar, and during the break, we had a call that came in, and he said, and the question was, What's quicker, your son going through law school or going through the minor leagues? And, that's a hard question to ask, because I know several people that have tried to go through the minor leagues, and it takes a lot longer than 3 years in order to get up to the majors, if they ever get to the majors. The good thing about law school is you'll eventually become an attorney. Now, passing the bar exam may be another thing, but both of them are challenges. But again, I guess that's another similarity, that there are challenges that you have to jump through in order to become a pro at your areas of specialty. So again, this is Matthew Noyes, and I'm here to answer questions that you have regarding auto accidents. But what I often hear is a lot of people come up to me and ask me questions involving questions that they may have, or they heard that their aunt had a question or their neighbor had a question and stuff like that. And so I call these "Hey Matts," because they usually start with, "Hey Matt, what about this?" And so I'm going to address some of the ones that I've heard most frequently about auto accidents. And the first one I hear all the time is, "Hey Matt, what does it mean for Florida to be a no-fault state?" And people get very confused about what that means. Florida is a no-fault state when it comes to automobile accidents. But that doesn't mean that we don't look at fault. But rather what it means that Florida requires all owners of vehicles to have what's called personal injury protection coverage. And personal injury protection coverage, or PIP coverage, will pay for your medical bills and your lost wages, 80% of your medical bills and 60% of your lost wages, up to $10,000, despite whose fault the accident was. That's where no fault comes in. Your insurance company, even if you did not cause the crash, will pay your medical bills and your lost wages, a portion of them, up to $10,000, notwithstanding whose fault the crash was. And the purpose of that really is to try to avoid litigation. If you get in a car accident and you have to go to the emergency room, or you get checked out with your family doctor, and your bills are $2,000 and you don't have any real problem, PIP will pay those medical bills, and you don't have to bring a lawsuit against the at-fault driver for the minimal medical bills or minimal lost wages that there are. Nowadays, though, you go to the emergency room and you sit there for an hour and you have a $32,000 bill because of a CAT scan or because of other situations. And so the no-fault coverage is helpful on many cases, but $10,000 doesn't go too far nowadays in today's medical world. So no fault doesn't really mean that they really they stop looking at who causes the crash when it comes to liability for other damages. No fault just means that the initial medical bills and the initial lost wages will be paid by your insurance company, whether or not you were at fault for the crash or not. Now, that is a nutshell of PIP, because PIP can be very confusing. And so if you're involved in a crash, it's very important that you talk to an attorney who understands PIP, because your insurance, your car insurance, could be responsible for your medical bills, even if you weren't in your car at the time of the crash. Kind of crazy. Oftentimes I hear somebody who gets in crash, 20-year-old, let's say a 20-year-old gets in a crash in a friend's car while a friend was driving, but lives with mom. Well, 20-year-old doesn't own a vehicle. Mom does. He gets in a crash in his friend's car caused by somebody else. Mom's car insurance has to pay the PIP. That's what the no fault's all about. So no fault can be very confusing and in some situations. So it's very important that if you get in a crash, that you talk to an attorney who understands who's supposed to pay your bills initially. Bicycles, different. Pedestrians, different. So it's so important that you talk to somebody who understands who's responsible to pay for your medical bills under the no-fault statute or under the PIP statute. So the next hey, Matt, that I hear a lot about is, what other insurance coverage should I have to protect myself and my family? That is a very good question and so important, because insurance, there's many forms of car insurance. I'm going to just talk about car insurance. And because before I can even answer that question, I guess I should answer the question, hey, Matt, I have full coverage. Is that good enough? Absolutely not. Full coverage means nothing in the state of Florida. Full coverage in the state of Florida means that you have that PIP coverage that I talked about that pays for your medical bills up to $10,000 at 80% and your lost wages at 60%. And it also, you must have property damage coverage, meaning that if you cause a crash, your property damage will pay for the other person's vehicle or the stop sign or the light post or whatever up to $10,000. That's full coverage. PIP and property damage. You didn't hear anything that talks about what protection do you have from being sued if you cause a crash. You didn't hear anything about what protects you if your bills are more than $10,000. That's why the other insurance is so important to talk about. In fact, that's why our firm is always willing to take a look at your policy to give you some advice of what coverage you have, explain that coverage to you, and then give you recommendations of additional coverage. We do that free of charge. You don't need to be a client of ours. We welcome that. You can just call us at 727-796-8282 and set up something for us to review, and we're happy to do that. But really, the two main coverages that I really want to talk about is bodily injury liability insurance and uninsured motorist coverage. Bodily injury liability insurance is that insurance that protects you should you cause an accident. Or I'm going to call it BI, bodily injury liability coverage. Bodily injury liability coverage is not required in most situations in the state of Florida. Sadly, about 33% of the drivers have no bodily injury liability coverage. They're not breaking the law because it's not required. But 33% of them don't, and another about 33% have only $10,000 worth of bodily injury liability coverage. That means about 66, almost 2/3 of the drivers are driving around with inadequate liability coverage. That if they cause a crash and they cause you to get injured, there may not be bodily injury liability coverage or adequate bodily injury liability coverage to pay for your damages, to compensate you for the medical bills that aren't paid by PIP, the lost wages that aren't paid by PIP, the pain and suffering that you have, the medical bills that you may need into the future. All those things would be covered under a claim for bodily injury liability coverage if the driver had BI coverage. If he didn't have bodily injury coverage, yes, you can bring a lawsuit against the at-fault driver, but in most situations, you would have to go to a jury trial and get a piece of paper saying that you're entitled to X, Y, or Z, and then try to collect that money from the at-fault driver. But in most situations, if they didn't have the funds to buy bodily injury liability coverage, they most likely didn't have the funds to satisfy that judgment that you get entered in your favor. So bodily injury liability coverage is important in two ways. If you are injured in a crash caused by somebody else, it's so important to know what their bodily injury liability coverage is. Too many times my clients come to me and say, I'm not worried. They told me at the accident scene that they had full coverage. Now, that's not any good. We have to find out exactly what the bodily injury liability coverage is. And then it also is beneficial that if you cause an accident, you want to have bodily injury liability coverage, because if you cause an accident and cause injury, then the person that you cause injury to can make a claim under your bodily injury liability coverage, and your insurance protects you from a lawsuit that may be brought against you. The insurance company would also have to hire an attorney to and pay for the attorney should you be sued if you caused the crash, and that's under your bodily injury liability coverage. So bodily injury liability coverage is so important for you as a owner, because it protects your assets, but it's also so important that if you're injured in a car accident, that it's important that we know what the other person's bodily injury liability coverage is. And on a side note to that, bodily injury liability coverage is not just for the driver. If someone comes to us and says that they were injured in a car accident, we look for bodily injury coverage, not just on the driver, but also on the owner of the vehicle. So it's so important that after a crash, you make sure that you know the rules, kind of like that baseball player, that you know the rules of who's supposed to have coverage and what claims can you be making based on the facts of the case. So bodily injury liability coverage, so important. But the most important coverage to have, I'll say it again, the most important coverage to have to protect you and your family is uninsured motorist coverage or underinsured motorist coverage. As we talked about, bodily injury liability coverage protects everybody from your bad driving, but it does nothing to protect you from other people's bad driving. But uninsured motorist does. Uninsured motorist coverage, or coverage, stands in the shoes of the at-fault driver who may not have any bodily injury liability coverage, or inadequate or not sufficient bodily injury liability coverage. That coverage is the most important coverage because it protects you and your family from everybody else's driving. I've had situations where my clients come to me and I look at their policy and they have $100,000 worth of bodily injury liability coverage, and they reject coverage. Well, in essence, what they've done is they spent all that money on insurance premiums to protect the whole world from their driving and didn't spend a penny to protect them or their family in the event that somebody else causes an injury and that does not have adequate bodily injury liability coverage. So coverage is so important in every case. There's too many times I've had a client come in after a crash and there's no bodily injury liability coverage and there was no coverage, uninsured motorist coverage. In essence, there's nothing we can do for them because there is no avenue that you can reasonably collect compensation for the injuries and the inconvenience and the medical bills and the lost wages that were incurred. Again, yes, you can sue the at-fault driver, but if they don't have assets, it's unlikely that you'd ever be able to make a recovery against that tortfeasor or that at-fault driver. But if you have uninsured motorist coverage, you can make a claim for that person's bad actions. And then your uninsured motorist carrier can go after them and try to collect a judgment against them for monies that they paid out. So check your policy. Uninsured motorist coverage is the most important coverage to have. So important. Check it. And I try to say that every show that we have, but notoriously, I have a client who comes in that had an accident and there was no coverage. And so we tell them, you got to get coverage. You got to get coverage. And 6 months later, a year later, they come back and they don't have uninsured motorist coverage again. And they're involved in another crash caused by somebody who didn't have adequate BI coverage. So we can't help them for a second time. Now, that being said, I've also had it on the other side. I've represented a client that did not have coverage in the first case. And I think it was about a year and a half later, he got in a pretty bad crash again. Somebody ran a stoplight and hit him. And he said, Matt, thank you very much. I listened to you last time. Now I have uninsured motorist coverage. And thank goodness he did, because the at-fault driver who ran the red light didn't have any bodily injury liability coverage. So we were able to make a claim under his coverage. So uninsured motorist coverage is so important to have. Make sure you check your policy to get it. If you can get stacked coverage, make sure you get that. We'll talk about stacked coverage on another episode of FLA Law on the radio. So again, this is Matthew Noyes. You're listening to FLA Law on the radio, and I'm just going through a few hey Matts having to do with auto accidents, because really that's what we do in our practice at Perenich, Caulfield, Avril Noyes. Most of our practice is helping people after automobile accidents, albeit we do spend a lot of time helping people after trip and falls and other negligence claims. I do a lot of workers' compensation claims. I also do a lot of Social Security disability claims, because those are situations where people need help. They need legal guidance. They're fighting through a legal system that just doesn't put the injured person first. It makes it so hoops and hurdles that you need to jump through. In a workers' comp case, for example, before you can really go in front of a judge, you have to file a petition for benefits, but you have to e-file the petition for benefits. Well, the average construction worker, the average hardworking store clerk doesn't know how to file a petition for benefits, doesn't know how to get the proper information needed to get in front of the judge, doesn't know the rules needed of what medical testimony. And so that's why we do what we do. We're here to guide them through the legal maze, whether it is a car accident or a workers' comp or Social Security disability, because there's so many things that you need to be able to do, so many hidden rules that you may not know about, but you need to know about if you're going to be successful in your case. So let's go to the next hey Matt. The next hey Matt was, hey Matt, who pays for my property damage after a crash? We kind of talked about that a little bit. Property damage coverage is required in the state of Florida. That means that if you cause a crash, you're required to have insurance that pays for the other person's property damage to their vehicle or to the property. That sounds wonderful, but most property damage claims are only policies are only about $10,000 worth of coverage. In today's age, you get a scratch on or a dent on your bumper, that $10,000 is going to go pretty quickly. And so what happens is that if the person does have property damage coverage, it may not be adequate enough to pay for all the property damage that you may have suffered in the crash. Also, if there's other vehicles involved in the crash, then there's only $10,000. If there's 4 vehicles involved in the crash, then it's unlikely that there's going to be adequate coverage to pay for all the 4 vehicles. So yes, there is property damage, and so if you get hurt if you get involved in a crash, and you need your property damage taken care of, you should initially go after the person who caused the crash. If that person does not have property damage coverage, doesn't have any insurance, yes, they are breaking the law because they're required to carry property damage, but there's many people that don't have any insurance. Or that person has property damage, but not enough to pay for all your damages or all the damages to all the vehicles involved, then it's important that you have comp and collision on your policy, because comp and collision will pay for the damages in situations like what we just talked about. Comp and collision will also pay for your property damage if you caused the crash. Remember, if if you didn't have comp and collision and you caused the crash, your property damage pays for everybody else's property damage, but not for yours. And that's why comp and collision is so important to have, especially if you have a newer vehicle, because too many times there's not adequate property damage coverage, or there's situations that you may cause the crash and you need to have your car fixed. And so that's who pays for your property damage after the crash. The next one kind of leans right in there is, hey, Matt, who pays for my medical bills after the crash? Well, we kind of talked a little bit about that in when we talked about the no-fault statute. And that is your insurance pays initially some of your medical bills. Your PIP coverage, personal injury protection coverage, will pay up to $10,000 in medical bills, or 60% of lost wages, but combined up to $10,000. But after the $10,000, your insurance company is not responsible. Your car insurance is not responsible to pay for your medical bills because your PIP has been exhausted. And so what happens? You have to then, you say, well, gosh, I'll just submit the bills over to the at-fault insurance company and they'll pay. Absolutely not. They will not pay your medical bills as they are incurred, even if they admit 100% liability for the crash. Because insurance companies want to pay you one lump sum amount of money and then have you sign a release of any and all future claims. They don't pay as you go, so to speak. So what happens is that the attorney is gathering the puzzle pieces to submit the claim to the insurance company, and one of those puzzle pieces are all the medical bills. And at the time that is ripe to submit the claim, usually when you reach maximum medical improvement, that is when the attorney submits the medical bills that are unpaid, not paid by PIP, over to the at-fault insurance company's bodily injury liability carrier and incorporate that into the claim for the injury.
Hey, Matt.
Yeah.
What if you're driving a rental car? Do all your royalties and stuff, if it were your own car, follow that with you?
If you're driving a rental car and you get hit by somebody, your car insurance will pay for your PIP same way. However, if you get hit by a rental car, the property damage, the bodily injury is not necessarily required. Renters do not have to have bodily injury liability coverage in a rental car. Totally wrong. It's a federal amendment where it's called the Graves Amendment, and it says that although owners of vehicles are responsible for the drivers of their vehicles, we're going to carve out an exception to Hertz, Budget, and all the other rental car companies that say, even though you're the owner of the vehicle, you're not responsible for the driver of the car. And so they do not have to carry bodily injury liability coverage. Now, in most situations, they'll pay up to $10,000 worth of bodily injury liability coverage. But the Graves Amendment gives rental cars a free rein not to have coverage, which is most ridiculous for me because they charge people to drive their vehicle. They get paid for using their vehicle. If I let my friend drive, no compensation to me whatsoever, but I let my friend drive and he causes a crash, I'm responsible because I'm the owner. So it just doesn't make sense. It's just a protection that rental car companies have that we fight on a regular basis, but it's a federal law. It's not even a state law. It's a federal law that gives them protection. And so that is even a stickier situation that you have to deal with. And because especially in Florida, we have a lot of tourists that are driving rental cars. And so whenever we see a rental car company, we have to worry about whether or not there's going to be coverage involved. Now, you can have your personal injury protection coverage still provides you your medical bills if you get hurt in a car accident involving a rental car. Your liability insurance in some situations will protect you if you're driving a rental car, but also the renter can purchase bodily injury liability, and then that insurance would protect somebody if they cause a crash. So there are ways that if a rental car is involved, then you can still make a claim. But that's a good point, Ed, because what we also see a lot is Uber and Lyft. Uber and Lyft cases, they're like taxi cabs have certain protection, but Uber and Lyft doesn't. In fact, Uber and Lyft are required, and other ride-sharing programs are required to carry substantial liability coverage if their drivers cause a crash. So if their driver caused a crash and there's somebody, if there's a passenger in the vehicle, their liability coverage is $1 million worth of insurance coverage.
But now the driver itself of their car would have normal insurance that would cover that, no?
The Uber driver?
Yeah, the Uber driver always drives their own car.
Right.
So that car has to have proper insurance to be on the road.
Yes, but all personal automobile vehicle policies have an exclusion if you're doing ride sharing. And so if you have an exclusion for doing ride sharing, you have to have another policy. And
so if I pick up a friend, take him to the ball game, and we get in an accident, then he is covered.
He is covered. Yeah, if you are just your friend and you pick him up, he's covered under his medical bill would be paid by his insurance company or a resident relative. If you cause the accident, he'd make a claim against your liability coverage. If somebody else caused an accident, you and him would make the claim against that liability carrier. So, but when it's Uber, it's very important that we make sure that you get the right information and the right insurance company for Uber, because Uber has several different insurance companies that provide coverage. And so it's like trying to find a needle in a haystack when it comes to an Uber driver. But that's one good thing about the law is that you do have protection if you are hit by an Uber driver. But conversely, if you are in a Uber vehicle and somebody hits the Uber vehicle, Uber is not required to carry uninsured motorist coverage. And so you may be still in a situation that if the at-fault driver didn't carry liability coverage or inadequate liability coverage, there may not be a way to compensate you for the injuries you sustain as a passenger in the Uber vehicle. So, but if an Uber driver causes a crash, the passenger has a claim against Uber, and the other vehicle would have a claim against Uber if they're the ones who caused the crash. So that is the Hey Mats. It was a joy to be here this week. Jacqueline will be here next week, and then I'll take over for the rest of the March visits. But thank you very much. We are proud to be part of the Tampa Bay community for 70 years. We are here to help you, whether it's on FLA Law or through usalaw.com, our website. We're Perenich, Caulfield, Avril Noyes, personal injury attorneys since 1955. Drive safely and good night.